Good morning, ladies and gentlemen. Despite the drizzle outside, the energy inside is high. We are all set for day 2 of the event with insightful sessions, meaningful connections, and a little extra warmth for amazing attendees. Let's make today even more impactful than yesterday. Stay inspired, stay curious, and rain or shine. So for this, now I'd like to invite our session 6 speakers on the stage. Mr. Kirk Sigmon, partner at Banner Witcoff from US as a moderator. Joining us as the panelist is Xinjiang partner, Llinks Law Office from China. Dr. Marc Nathmann, Flexhub Digital Group and ING Group from Netherlands. Tingting, member of ACLA International Legal Professionals from China. Chinwe, Alli, Group Legal Director, PalmPay from China. And the session is AI and IP legal consideration for IP ownership in artificial intelligence creation. I welcome you all on the stage. Over to you, moderator.
Coming up. I'll take this seat so I can hide. Go for it. There and there. Perfect. That one there. Perfect.
Hello everyone, good morning. Thank you for coming to the panel. This is going to be on AI and legal ownership. And instead of keeping these a little bit formal, we'll keep it a little bit more relaxed today. I know that everyone's still waking up a little bit. So we'll have everyone introduce themselves. Let's just go down the panel. If you don't mind introducing yourself a little bit, your background, and perhaps a little bit about your background with AI.
Okay, thank you. My name is Yang Xun. I'm now a partner at Llinks Law Office China. And this year is my 22nd year of my private practice. During the last more than 20 years, I always practice in the technology-related law area, including technology transactions and also cybersecurity issues. And for the last 5 years, I worked a lot on the AI sector, helping both the technical guides in developing their new AI products and also the startup companies to form the AI strategy, especially on the intellectual property protections, data protections, and compliance issues related to the operation of AI products. Thank you.
Yeah, first of all, thanks for having me. My name is Marc. I'm very, very pleased to be here in China again because with China I have a very personal background because actually a few kilometers, okay, China is a huge country, approximately 200 kilometers away from here, my professional career as a lawyer began. My first job was as a lawyer working for an international law firm in Shanghai. And so I was very happy to see Shanghai again and also very happy to be in China again. My professional background is actually, I get 2 jobs like almost everybody now. Most of you have 3, 4, 5, I don't know. My core job is I'm working for the legal department of ING Bank. We are the largest bank in the Netherlands and also in the top 20 of the biggest global banks, and I'm working for the legal department and I'm in charge for, from Europe, of course I'm in charge for regulation issues. So I'm dealing with modern technologies, AI Act, Data Protection Act, and so on and so on, of course with a kind of focus on the financial services sector. Apart from that, I'm a co-founder of Flexhub Digital Group, that is a German-based IT company, and we are trying to bring artificial intelligence solutions into the German and also into the European market, and that is my second job, and that is why I almost had said I'm a techie, but I introduced myself as being a lawyer, and all the lawyers here in the audience know we are not that techie if you're starting talking with a real guy from Silicon Valley or wherever, but I'm trying my best to be as technology open as I can be as a conservative lawyer. So I'm very, very pleased and very, very happy to share some insights, especially considering the European perspective with you, and I'm so happy to hear and discuss with you opinions on artificial intelligence, especially if it comes to ownership of intellectual property, with an audience and with other people from almost around the world, and of course, in particular also the Chinese view on the things, which I'm very, very delighted to hear.
Hello everyone, good morning. Thank you to the organizers for having me today. I'm Chinwe, I'm from Nigeria, and I've been in China for about 5 years now. Qualified to practice law in Nigeria and also England and Wales. I started my legal career in Nigeria. I worked in a law firm, a full-service law firm, whereby I worked on major financing and project financing deals. And then thereafter I moved to China. I did my master's in China in international law, and then I started working in-house in an e-commerce company, and currently I work with PalmPay. PalmPay is a fintech company that has operations in Africa, currently has a full service operation in Africa and also expanding across the globe, practically in Asia, like Bangladesh, and also in the UK as well. My job focuses mostly on ensuring the company has like its regulatory compliance, and also as part of the services we offer also includes KYC and identity verification. In these services, we employ the use of AI and artificial intelligence to stream data, and also to ensure that we offer like the full services to our clients of identity verification. And in addition to this, I have my own practice on the side, whereby I'm a partner for my practice called Veil Law. This practice is mostly geared towards bridging intellectual property protection in Africa. So, for example, if Chinese clients would like to protect their intellectual property in African countries, then I would offer this kind of service to them. So today I hope to speak more on the intersection between intellectual property and also AI, and also learn so much from my colleagues on this panel, and also from the audience as well. So thanks all, and nice to be here today.
Good morning, everyone. My name is Tingting. I'm a business lawyer, but with some technology background. So a small part of my work is related to IP. Thank you for coming.
And last and very significantly least, my name is Kirk Sigmon. I'll be moderating this panel. I'm a partner at Witcoff. I have been writing about AI for the better part of 10 years now. One of my first publications was on the programmatic destruction of copyright law using automatic generation. Nowadays, I'm finishing off a master's at Dartmouth, which is the home of AI, where they started it all, which is kind of fun because everyone thought they were crazy for decades. But I'm working with them right now on some research using that AI and field programmable gate arrays, so some really nerdy stuff. I will not bore you. But I'm excited to moderate this panel. We have some fantastic folks, and what I'd like to do first is, I know, Jennifer, you have a presentation for us to begin, so let's go ahead with that. I have a clicker here. Would you like to stand here or sit? Either way, we can give you control. So perfect. Oh, that's your phone, unfortunately. Here we go. I'll give you this. Would you like to stand or sit?
Okay. I think I would prefer standing here. Can you say clearly? This is my topic I wanted to share with all of you, legal and IP perspectives and the full life cycle of industry-specific models but obviously I cannot finish it within 15 minutes. So I would only choose a few slides to discuss and share. We can see here, this is the structure of the AI model lifecycle. It includes data connection, pre-processing, training, development, testing and validation, deployment and commercialization, and maintenance and updates. And you can see very clearly that during the stage of the model maintenance, this is actually a feedback to collect all the user inputs and the AI outputs and user feedback and the continuous AI outputs to retrain the model and to improve the model to be better. So this is actually a closed loop. So when we're talking about illegal connection, it is obviously at the collection stage. But if we are talking about identification data or sensitive data, it is we need to focus on the pre-processing stage. But if we're going to talk the algorithms or trailing pipeline itself, we need to focus on the model trailing. So the focus of this session today is the ownership and the rights of AI-generated content. So actually we need to focus on model maintenance and data recollection. Okay. If you want all the details, it is included so much, technology and things. If you want to have all the details, the registration desk, they have this file. So I would only focus on the number fab issue, ownership and the rights of the AI-generated content. And all the fab issues are the companies, are the issues which companies as the industry player would most concerned. You may pay more attention to this. Sometimes I would chat with GDP for killing my time. So I asked you the same question 3 times, but you responded with 3 different answers. He told me, I treated as him. He told me AI currently cannot fully replicate. You will know why later, because it's about the infringement to the third-party rights. Then I asked him, if another user asks you the same question, which answer you are going to respond to him? He told me, I would like use the insight from our conversation to provide a balanced and a comprehensive response, which means the new answer to the new user is different again, because he cannot fully replicate this content. Then I ask further, is that because I trained you better? Then I improved your answer? So you are going to use the best answer you think to respond to other people? He said, exactly. Then I asked, is that because the more smart people you made, then the best answer, the improved answer would come to as a result? He said, in a sense, yes. So let's take a look at the terms of the service published by OpenAI. I use OpenAI as an example because it's a closed source model. It's not an open source model. It is very typical. You can see from the ownership of content, it says the user owns all the rights of the ownership, including the user inputs and the AI outputs. But from our use of content here, by agreeing these terms of use, and the user actually grants all the right of the use to the OpenAI, to all the user inputs and the AI outputs. The issue here is, you can see, the user cannot use AI model service for any illegal, harmful, abusive activity, especially the first one, in a way not infringe anyone's right. As everyone in this room knows, ownership means some rights, but it also means some liability. So it's kind of sophisticated commercial design for OpenAI to transfer the liability and the responsibility from the AI model developer to the user. Let me think. And this one, especially if a user is a business or enterprise, the business user need to identify OpenAI to be harmless. So I'm just thinking, if original data owner have found that its copyrighted work has been infringed, so if he is going to initiate a legal proceeding, then against whom? The user? It's very unfair because user would defend, I couldn't control what the context the AI model is going to output. So why I should be responsible for this? Against OpenAI? Okay, I will tell you first. The AI model is responding to the user inputs. We cannot control the AI model outputs because we cannot control what the inputs the user is going to make.
Sorry for interrupting. Actually, in China, we have two cases on exactly the same issues about the ultimate case. And the decisions are contradictory to each other, but actually the court has its own ruling. But I will finish.
Okay. Because I rationed this because it is actually, I think it's a sophisticated designing of the developer to have the contractual assignment of the risk management. But if we're talking about the illegal connection or the data trailing type issues, we can discuss later. Yeah, thank you.
All right, folks. All right, folks, there's a lot to unpack there, so let's try to take this sort of step by step, because there's a lot going on here, and there's a lot of forms of AI, so and a lot of forms of IP. So let's begin with training data. And we talked a little bit about this beforehand. A lot of different countries have, needless to say, taken different stakes on this. So for example, many of the US clients I work with openly admit that candidly they steal it, right? So even OpenAI recently got caught using what was called Z Library, which is essentially an infringing repository of books and articles and things like that they absolutely stole. And their contention in the US context, at least, is that they're allowed to do that because the training of the model basically devolves into nothing but mathematical representations that work, yada, yada, yada. Needless to say, people like Scarlett Johansson strongly disagree. They're suing. But let's start off with everyone's perspective on this. So from the perspective of training data, what are your thoughts on ownership? What are sort of the trends you're seeing in terms of how jurisdictions are approaching it?
Yeah, actually this is an important issue in the AI industry because the development of AI relies on a large volume of data, and generally speaking the data comes from the public domain area. About 5 years ago, I advised a startup company which produced an AI generator program for drawing pictures, like Photoshop, AI generated Photoshop. They use publicly available pictures to train the AI model, such as the cat of Tingting, Tingting platform, or the Tianmao, these kind of public available images. They asked me a question: is it allowed for me to use the copyrighted works without authorization? Well, different from US law, where there are 4 factors doctrine. In PRC, we only have exceptions, which is considered fair use. And the use picture for AI training does not fall within any of the exceptions. However, I don't want to say no to my client, because I understand that they must do that. So I try to develop a methodology to help the client to balance the risks and benefits. Law is not about right or wrong, it's about the balance of risk. So I advise them that if you are able to control every training stage internally, and you can control the output of the result, it only produced to those who have duly authorized. For example, if you are going to draw a picture for Tianmao, you can use the output, the cat, for the event company with authorization. But for the rest of the world, you do not produce the work exactly the same or which is confusionally similar to original work. If you can do that, the risk is manageable. Now, after 3 years, although we don't have a copyright case just like the States, but we have some similar case, which I believe is consistent with my suggestion. Now, there are 2 cases about voice performance. Now, in that case, in the first case, voice performer sale is recording to the company. And then company sell the recording to an AI company. The AI company uses voice to generate an AI model which can read the textbooks, which consider the same or similar voice of the actor. Now, the voice actor may launch a suit against the AI company, as well as the buyer of the voice recording. And the court determined that it's an infringement. Now, although the copyright of the recording has been sold, but it's moral right. The voice belongs to the moral right. So you use voice to produce AI which is similar to the original person, it constitutes an infringement. Now, the use of the unauthorized voice is constitutes infringing the moral right. 1 year later, another voice actor sued another AI company for using its voice for training an AI model. But in that case, the court determines it's not infringing. Okay? Although the original voice was used without authorization, but the final result of the AI does not produce the exact same sound as the actor. It's a mixture of every actor's sound creates a new sound. So even the fingerprint of the voice is the same, but the character, the feature of sounds is different. It's not confusing. So the court believes that although during the initial stage, the AI company did use the voice without authorization, but there's no consequence. Right? The final result is not confusing. So because the training of AI relies on a large volume of no public data, we cannot impede the development of AI technology. So the public needs to allowance, maximum allowance for the rule for development. Now, these two cases look contradictory, but they follow the same meaning. That is, whether the original data is considered legal was somehow influenced by the final result. That is, I think, is very important decisions which will lead, that will guide the people, guide the AI company, how to use the publicly available data. Yeah.
Well, the situation in the European Union is slightly different since we have the so-called AI Act. The basic approach of the AI Act is not the copyright or IP approach, of course. What do we mean, or what does the European Commission and the European Union want with the AI Act? It's a regulation of AI. If you compare it, it's hard to compare different jurisdictions, of course, but if you try to compare the situation in the European Union with the situation in China it is, I don't know whether it's hard forbidden, but it is not that easy, let me put it like this, to use or have foreign-based AI systems in the People's Republic of China. The European Union is fearing that AI systems might interfere with various goals of the society. So it's not only infringement of copyright laws, they're more coming from what could happen if AI interacts with social media. Can we produce fake news? Probably can it destroy our society? I mean, the fear in Europe usually is big if it comes to new technologies. There is I don't know whether you know that saying, but there is a saying in Europe, it is called German Angst. German fear, because Germans usually we are fearing much, especially in the future. And the same applies for the whole European Union. I see the guys from Europe smiling, you know that problem, You know it, it is also Italian fear, Also you have German Angst. So we try to regulate, and the problem of regulation is if you're trying to set up a regulatory playing field for future developments, you don't know the technology to the end, so regulation can easily also block technology innovation, and that is important to know for the background. But if it comes to IP, and especially if it comes to training data, AI Act stipulates Article 28, and Article 28 more or less clearly states that there is two options actually. Option one is the owner of the copyright can opt out. So I can opt out and simply prohibit others from use, also for training purposes, to use my copyright. That is option one. And the other option is, if there is no opt out, you have to make the third party's rights transparent. That sounds very quick and dirty. Easy approach, quite simple. Let's do it like this in China or in the US. Take it to the Congress.
They probably listen.
Of course not. But I will explain to you why they probably, it's not the worst idea to not listen to this, because this sounds pretty easy. The problem you're facing is, first of all, there is not a register for every single IP right. So I simply, especially as a user, and with the user, I don't mean the user who is prompting. I mean the user who is programming an AI system and just trying to train the system. I simply do not know whether the machine uses foreign or third-party copyrights. That is the big problem. And then you have all these documentary issues, and that is a real that's bullshit. Because you're producing documentary. Sorry?
Is that a technical term?
Bullshit, yes, of course. Yeah.
Just checking.
Yeah.
Maybe it's like a Germanism.
Yeah, you're producing documentary, and this is very, very hard, especially if you think of an AI company that is probably SME business. They are probably smaller. They can't hire 100 lawyers and 500 compliance officers to do all this and deal with all these documentary stuff. And if you really dive deeper into the development of technology, what do you have to be? You have to be agile, you have to move fast. I don't want to quote, but I love this quote. Move fast and break things. That is how business is going in this respect. And this is hindered by regulation. So in general, the approach is all right, of course, but you have to keep in mind that it's very complex to have all this documentary. This is probably governmental and officially checked by regulators, and you can be sued to don't have a proper documentation. And that is also, again, a financial risk, because even at a training phase, you're probably facing a lawsuit, and that is not what you want. So there is, of course, in the European Union, and this is unique in this beautiful world, there is an approach to deal with all this stuff. But I don't think that is the final answer, and probably not that is the best answer. But that is the European standpoint, and if you're thinking about, shall I develop my AI models in the European Union, be aware of AI Act, be aware of these obligations, and I mean there are also in Europe well-paid but good lawyers that will help you to deal with this stuff. If I may look a little bit into the future, and I'm a very optimistic guy, I don't think this will be a game changer, meaning this won't hinder AI companies in the European Union, because in the European Union we are simply used and we can not easily but quickly adapt with regulation. That is where European companies are very good in, especially banks. We're used to that in 30 years. However, I think that if I was an AI company, I would probably go to other jurisdiction in the training phase.
So with respect to the training data, I think what's settled in almost all jurisdictions is the fact that the copyright owners are the rightful owners of this data. But what is yet to be settled is the actual use of this data and the infringement that proceeds where AI companies utilize this training data. So like you rightly said, like in the EU and also maybe in the UK, we've seen regulations coming out to regulate this and see things like text and data mining act, whereby the users can opt out with respect to commercialized use of this training data. But then we now see areas whereby in some jurisdictions, like let's say the US, and then some other common law jurisdictions whereby the legislations are very silent on this issue. And what these AI companies or the AI users would mostly rely on is most like the common law doctrine of fair use. And that's where the issue comes in, because right now we see the courts are trying to balance the interests of the copyright owners and with the interest of the AI companies. So with respect to this fair use doctrine, I would say gearing towards the the train of thought or the flow of thoughts of the copyright owners. I see where the copyright owners are coming from, right? They are the owners of this data, and like without not using AI as an example, like using humans, like before, like a human being would utilize a copyrighted material. At least we're always expected to give like citations, right? You're supposed to say, oh, this data came from a particular source. But then we've seen some AI tools would replicate this data without making any reference to the source. I know, or maybe ChatGPT, if you like prompt ChatGPT, ChatGPT can give you the source whereby it's obtained its data. But there are also so many other AI tools, AI solutions that don't reference the source, and that's a key infringement to the rights of these copyright owners. So if we as humans are expected to give these citations, then why can't we require the AI tools to do the same? So the AI tool relying on fair use, or the AI companies relying on fair use doctrine, they're missing that point, because at least the least they can do is to make this these citations or referencing to the copyrighted work that they use. So I would say when these regulations in different countries that have not yet developed their the laws on AI protection or the intersection with intellectual property, I would say that should be a starting point to mandate this AI tools or the AI solutions to do at least the basic minimum that's required of humans when we use copyrighted work of other users. And then with respect to the fair use doctrine as well, like the defense that is mostly put forward by the AI companies or AI tools is the fact that if humans are expected to rely on copyrighted work to train humans, then they can as well rely on this copyrighted work to train machines. So thereby they can they have no, like there's no control, or like there's no extent to how they can utilize training data that has been protected. But then we see that there are some copyrighted, there's some AI solutions that replicate these works verbatim. So now, where do we draw a line to outputs? So, like, what I mean is, when the AI solutions or the AI tools utilize this copyrighted work and they use this to produce like a new product. So I know the fair use doctrine is it has worked for a very long time, because there are restrictions to this. You don't use all, like, imagine if a work has like 100 pages, you don't replicate the entire 100 pages, you just replicate a segment of that data. So that's one restriction that should come to these AI tools or AI companies that utilize third-party copyrighted work. There needs to be a limit to the volume of data that they use. They can't just replicate 100% of this data. That's the first one. And then the second part should be the output. When you output this work, there should be a significant or like a identifiable difference between the outputted work that was outputted by the AI tool and also the copyrighted work. So whereby AI companies rely on the fair use doctrine and they replicate verbatim the work that is protected by AI, by IP, then it becomes a problem, because how then do we expect to incentivize innovation or to make people release new products whereby when there is no adequate protection for them, whereby an AI tool can also verbatim replicate their work. So I think these are like key issues whereby key issues that should be addressed in jurisdictions that don't have settled laws on this subject, and jurisdictions that currently rely on the fair use doctrine. And I'm calling on like jurisdictions like in the US and African countries that have not established their, they have not updated the IP laws, because currently the IP laws are working in like 100, like things that were in place like 100 or 50 years prior to today. So this is like a call to update all the IP laws, and to update, if we don't want to update the existing IP laws, then we should
set up a new law that would regulate these issues and also afford adequate protection to the copyright owners, and also still protect the interests of the AI companies as well?
I would say the training data would include the data developer collected and cleaned online, and also it could have the license to use the data already collected and cleaned by the data company. So I think the issues are different. Infringement existed in the collection stage and also in the challenge stage. And if the user intentionally or unintentionally inputs some text or prompts, then could have infringement to the third party too. So it's actually, I think there's so many elements we need to consider and dimensions to consider to determine this. I don't think it is really settled already.
I agree.
So let's flip the discussion a little bit over to the other side of the ownership question. So to give a little bit of background, the other side of this is the output of a generative AI model. So for example, artwork, textual content that it creates, even audio in some cases. So the US at least has taken the stance that in general there's a possibility that can be, there should be ownership there. And the reason why, in short, and this relates to a comic called Zarya of the Dawn that was submitted to the US Copyright Office claiming that it should be copyrightable, that prompt engineering alone can impart a degree of creativity that warrants copyrightability. Now, in the US, what they do is they sort of give themselves an out by saying, well, it's only to the extent that your creativity existed, therefore there's some subset of this, there's some content within this that you do not have a copyright ownership of because it is from the machine learning algorithm. In that case, it's a little bit uncertain, and a lot of jurisdictions have quite different perspectives on this. So I'll open up the panel. When we're talking about the output of a model, particularly the generative AI context where you've got the nice art or the music or whatever, where do you see this going in terms of ownership? For example, does your particular jurisdiction protect it? Does it consider it, sufficiently creative? Where do we fall on the spectrum?
Yeah, I would say the right question should be to what extent the AI-generated works could be protected. Because in China, the presumption is the AI-generated work can be protected, provided that you can demonstrate that the human input has been creative enough. Now, the creative does not mean the creative like patent. It means that you have used the output to reflect your idea in a innovative way. Now, actually, we have 5 cases on AI-generated content, and 2 talking about the text, and 3 cases talking about the picture, AI-generated pictures. I believe the 3 cases about AI-generated pictures are very interesting, and we can demonstrate how the court is thinking about these questions. Now, the first case is talking about a picture of a young lady sitting in the spring wind. Now, it's a lovely picture, and 1 year later, the creator found that a third party used the picture for its own the Witcoff. Now, to sue that person for infringement, that person defend itself by arguing that this is an AI-generated work and does not receive copyright protections. Now, in that case, the court ruled that the work is copyright protectable because although it is generated by AI, the AI is like a tool, just like Photoshop, and still reflect the creator's thinking, creator's idea in a creative way. Now, the creator used prompts to generate a picture, and the prompts reflect the extended expression of the creator. Now, this is the first case, the thing that called thinking methodology. Now, 1 year later, there is another case. In that case, the picture in dispute is about a balloon, red balloon, rest on a river. The balloon, together with the reflection of the balloon, form a red heart. Now, it's a lovely picture. And similarly, in that case, the court believed that the AI-generated picture can receive copyright protection. And the court actually went a little bit further. Is that not the idea of the blue on the river is copyright protectable, but the expression. What was the expression? That's the angle of picture, the light, the use of light, the combination of the colors. Now these kind of things are not ideas. They are the expression of the creator. The creator used AI as a tool to reflect its expression, just like people use a brush to draw a picture. Now, so in that case, the court supports the protectability of AI-generated work. However, in the third case, which the decision was issued just a few months ago. Now, in that case, the pictures is about lovely chairs made up by balloons, colorful balloons. Now, different from the previous two cases, in that case, the court ruled that the picture was not copyright protectable. The reason behind this is the creator only used a few lines of prompts. They say, oh, I want a colorful chair made of balloon. And the AI, the artificial intelligence, generates a wide range of chairs according to this very simple prompts. So in that case, the court believes that these prompts only an idea. It does not include the composition, the light, or the combination of colors, all these kind of expressive elements. So in that case, the court ruled that the picture does not receive copyright protection. So from these cases, we can see how the court thought. Now, it's not a matter of whether AI generated can be copyrightable. It's a matter of how the creator can demonstrate that it has enough input to the AI, and whether these inputs can reflect its expression, not only the idea. Now, this comes to the fundamental issue of copyright law. Copyright protects only the expression, not the idea. So I believe, of course, follow the same methodology and treat AI as kind of technology which can help us to express.
Yesterday I was even surprised and very happy and interested to hear that South Africa was it a patent? They patented a AI creation. That sounds super cool, huh? Isn't it? And it changed my mind because in Europe, the European Court of Justice ruled very clear: there is creation must be human. Full stop. That's it. Huh? Okay. Pretty easy legal situation. However, I'm a great fan of looking at the big picture. And if we are talking about what AI is actually creating, we are not of course, we are talking about funny cat videos on Instagram or WeChat. I love these. I also love playing around with my phone, taking a picture of Donny T, putting myself next to him, drinking a beer with him, or whatever. That is cool. Creating a comic is super cool. Writing a novel is super cool. But if you're talking with programmers, for example, IT architects, what do they do? In the past, and also today, but it is running out. The time is tremendously running out. When they were coding, they had these huge code databases. What do they do today? They ask ChatGPT, they ask Copilot, they ask artificial intelligence to give them the code. What do you do with the code? Probably you steer a nuclear power plant. You create financial models for investments, and with a simple code, you can earn millions of dollars, millions of yuan. There is a real world and economic worth behind everything on code. And first of all, that is the picture. That is what we are talking about when we are answering the question, is an AI probably the intellectual property owner of this particular code? We're talking about a market of billions of US dollars or billions of yuan or euro. So this question has to be answered and taken very serious. So what is the actual approach in the European Union? AI itself can't be a creator itself. Okay, that is clear. Then who is the creator? Probably the one who is prompting. And there is one single rule, and that is not so different from the Chinese approach, from the US approach, and that is really good news for us all, because on an international basis, we are speaking not in the detail, but in the general picture with one opinion. And the opinion is, the more creative the prompt, the more likely it is that the prompter is the creator. And that is, I think, the very clear ruling which you can follow. So if I make a prompt, and I'm not going so deep into the details and counting words in the prompt or lines or whatever, but if I'm very creative and the outcome is a code with which I can steer my nuclear power plant, my gas pipeline, whatever, I will be the creator, and my IP as an output of the AI is being protected. But let me, or allow me please, to be a little more visionary, because the technology is developing so quickly. And yesterday I learned a beautiful quote from Elliot. Thank you for that. Before we are talking about artificial intelligence, let's try our human intelligence. Of course, that is true for today, and I'm pretty sure this will be true for tomorrow and probably next year. But I'm not going to judge on 5 years or 10 years in the future, and if you have the speed of the technological development we're facing right now in back of your mind. And then you have to think and rethink this approach, and then you will probably end up thinking towards the direction the colleagues in South Africa were thinking. And I mean, today, probably we think, hey, that's a nice joke. But probably in 10 years, we will think this is really visionary. How to deal with that? That is the whole question. I mean, somebody has to be the creator, and everything has to be, in the end, put back to one single human or to a legally relevant entity. And there is one figure that is in the very beginning being discussed in the legal world, and that is the so-called electronic person. When I first came across the electronic person, I was thinking, what the hell? What shall we do with this? What shall it be? And then I was starting to think, hey, we know comparable things. We know a legal person. Hey, a corporation is a legal person. And we need the legal person, a corporation, to have a legal entity that we can probably sue if there is infringement. But on the other hand, we also have it to make this legal person be a person that can own rights, that can own property. And if you think a little bit in the future, probably an electronic person might be the solution to simply allocate intellectual property onto this electronic person in such cases where the artificial intelligence, the machine, and we're talking about machines, we're talking not about humans, we're talking not about cats and dogs, we're talking about machines. Yeah? To make the machine legally responsible. And if the machine is legally responsible, it is easy to allocate rights onto the machine. And this is probably a solution for the future to build the bridge between South Africa and the European Court of Justice.
Yeah, quite interesting. So, like you said, with respect to the outputs, like the ownership of this particular IP, what is mostly settled is the fact that we actually need like an element of human participation. Save for the South African case, which is more like a patent. The South African Patent Office actually granted a patent to a robot, like an artificial intelligence. So aside from that, I think what is pretty much settled in almost all jurisdictions is that human element. And like when I saw the South African judgments, I noticed that this particular person, like this applicant, also applied in so many other jurisdictions, like the UK, US, Australia.
I apologize for on behalf of America for Dr. Thayer, he's a pain in the ass.
So, and he was actually rejected, okay, say for in Australia where it passed the first, the courts, but then I also read that it was overturned. So currently just South Africa now. But then what came to my mind was, if we give robots or artificial intelligence the rights to own property, how then do we deal with enforcement? So how can they enforce the rights? So at the end of the day, we still have to come back to the human element, because currently artificial intelligence don't have any power to do anything, right? Like the laws are silent on this right. Like laws currently right now are made to either protect humans, animals, or the environment, right? We don't have like laws that are targeting these robots or artificial intelligence. That's probably because we at the end of the day still see that they are to the benefit of humans, right? So it's still going to be a human who prompted the AI or who developed the machine that ended up filing for this application. So we still find out that we still have that human element, right? So even the South African office that granted a patent to a robot was not per se granting this rights to that robot, right? It still granted the right to the owner of that machine. So that's why I would still tend towards the legislations that require that human element to be present before we can actually give this qualify this creations as intellectual property, because currently as of today we don't have these rights cannot be fully exercised by this machine. They are still indirectly going to be exercised by the individuals.
Yeah, you know what, in China we have a discussion about what kind of job are secured in the age of AI. And the answer is lawyers and accountants. Why? You cannot put AI into jail. No, but if you are AI, not so.
Yeah, that is true. But let me just interfere a little bit, facing the US colleague. In China, probably in Europe, we also will say you can put a company into jail. Yeah, but in the US, they have criminal law for companies too.
Oh yeah, well for people too.
Yeah. You of course don't put Microsoft in jail, but you will find them.
Yeah, sure.
Well, if we're talking about the authorship of the AI-generated content, and Authoric simply just claim that we don't claim the ownership, but the OpenAI will assign all the ownership to the users. But the problem is that the AI haven't been completely explainable and interpreted. So there is a trend and the policy change in, I think, different jurisdictions. Generally speaking, the world have a request to make the AI model to be expandable and to be completely transparent. But problem is that, like ChatGPT is a closed source. No matter I was an author of the copyright work or I'm a user of the AI-generated content, it is too difficult. It's not feasible and practicable to improve that my copyright has been infringed. I think that would be the issue. Yeah, thank you.
So thus far we've spoken quite a bit about the general concepts involving, say, copyright. To some degree we've touched a little bit on some trademark and trade dress issues, at least inferentially. Let's quickly, and I promise you pull this short because this is a bit of a more niche topic, but the patent side of things, right? So one of the big developments recently has been this question of the extent to which different patent offices are going to grant claims directed to artificial intelligence using inventions, I'll say, right? Because in general we can all assume that the quintessential bog standard use of, say, a machine learning model is at least now obvious. It's what we call 102 and 103 prior art. But the question then remains, what else is patentable in this sphere in different jurisdictions? So in the United States, as a quick aside, there was a recent case of 3 or 4 weeks ago, time's hard, called recensive analytics. It changed things a little bit, but not a lot. The USPTO has long since been giving pushback. So the basic takeaway, and I'll talk to you later if you want to know, is it's very hard to get quintessential standard uses of what they call generic machine learning models as a patentable claim. They just don't like it anymore. So most USPTO examiners are telling us to go fuck ourselves if we try to get those claims. So let's talk about different jurisdictions. In the different jurisdictions, and we'll keep it quick because I know this is a deep topic and kind of boring at times. What are you seeing in terms of the patentability of machine learning inventions?
Well, this question can be divided into two sectors. One is the machine learning technology itself. The other is the outcome of the machine generated content or works. Now, to the first questions, generally speaking, we can patent the kind of model, the generated machine learning methodologies, and especially combining with the machine itself. But we generally do not patent the methodology itself, or the algorithm. Now, this is our fundamental rules. Actually, I'm working for a number of the AI companies. They have developed some flows. I would say the detailed industrial flows to use machine learning technology to generate content or work for people. Now, the digital working process can be protected, provided that you can tell the examiner that the process is somehow created, not only rely on the machine learning technology itself. You must show that the differentiation from the fake methodologies. Now, the second angle is about the achievement made by machine learning technologies. Generally speaking, they can be protected subject to the same standard of patentabilities. Actually, the patent examining officers have issued a number of standard rules for examining the achievements made by machine learning technology, especially in the drug area, the pharmaceutical areas. They use the AI to select the compound. Now, this is a tortured process. And the examiner's view is basically you can use any kind of technology to simplify the process, make your life easier. But we don't care about the process. We only think about we need to think about the outcome. Whether the outcome is creative enough, whether the guidance behind the outcome, behind the process, can demonstrate that the creativity is.
Yeah, I can keep it short. It's the same situation in the European Union. We, of course, look at the output. And it doesn't matter whether you use a highly sophisticated AI or a paper and a pen. If the output is innovative, new, and and reaches certain technical standards, you will get a patent on it. And that is absolutely correct, because it can't matter how you achieve. Because there are so many ways of achievement, and we simply look at the output, otherwise nobody could deal with it.
Yes, so I would also tell you your opinion. For what I've seen so far, it's mostly the output and also the human ingredients, right? So just like you rightly stated, AI machine learning is seen as a tool, as so many tools we currently have that has been utilized for invention. So these artificial intelligence and machine learning tools also have the same, are also given the same level of, they are also regarded as a tool that are required to add to the inventions. Yeah. So
I would normally recommend our R&D team to have a free-to-operate analysis first before launching an AI model project. If we cannot use kind of methodology or tools which has been patented, we have to design around by ourselves, because I think patent could be the most powerful weapon against industry competitors, or even against the large-scale language model developers. Even such patent has been created with AI together. Yeah.
Okay, so we're getting pretty close to time here, so let's just do kind of a quick round and really just kind of impart some wisdom that would be immediately useful for a lot of them in this room. So if you have some advice on what you're telling your clients and how to address the general issue of ownership of AI. So, what you're telling them now to better protect themselves, say 5-10 years in the future. Can you give us some advice for those of us in the room about what we should be telling our clients?
Well, the first advice is never be afraid. Lots of times ask me question, whether I can use public available data for training, is that infringing, or whether I use the AI generated content, will be infringing risk. I will say, then do that. I will find a way to mitigate risk. There is no area which is free. If there is free area, that's not valuable. So I will encourage clients to embrace AI, and I will help them to mitigate risk. The one issue. The second issue is, although the law is somehow vague in this area because the law is emerging, but we can always find the rule behind the law, find the methodology behind the law to forecast what kind of risk you will have and find a way to do that. Now, especially when you talk about the IP ownership, we talk about the possibility of infringement. The financial institutions ask me questions whether I use AI to generate content, whether the possibility of infringement. Yeah. Also, keep a record. Keep a record of creation. The prompts which you use can demonstrate your own way of creation. Right? This is a defense for copyright infringement. So keep a record, do your work properly, and leave the rest of the work to lawyers, the good lawyers.
Yeah, I totally agree with you. What I would like to add is, in the end, everything is still people's business, and most important for me is the more technology you use, the more advanced it becomes. Make your employees, your colleagues, your clients, make them aware of all these things. Otherwise you will end up with people doing whatever they will without thinking about it, because it's so easy. What is easier than risk your complete and entire company data by one stupid idiot who is not able to write an email on his own, pulls all the data into ChatGPT? Congratulations. Yeah? Of course, documenting, record keeping, proactive legal advice is very important. And if it comes to proactive legal advice, I really mean proactive. You need to have a kind of horizon scanning, I would call it, in action. So you have to scan the horizon for new regulatory, new legal developments. What are we facing? What are the plans with of the lawmaker? Speak with lawmakers. Get yourself involved in the lawmaking procedures and interact with them as quickly as you can. But the most important message is make your employers aware of what they are allowed and what they are not allowed, and simply inform them. Hey, show them if you're using ChatGPT and create whatever you do, probably you can or you might infringe other copyright laws and bring us in the situation that our company is sued and we will end up in lawsuit, and of course you will be fired.
Yeah, so coming from an in-house perspective, I would say one advice I would give to like my clients, right, would be while the IP laws on this issue are like quite unsettled, what is settled right now is the contract law, right? Yeah. So we need to be certain on the kind of agreements we sign with also creators as well as the AI companies. So we need to check, advise clients to check the content of the agreements, ensure that issues relating to ownership are clearly stated under those agreements, ensure issues related to liability are either passed on to the other party, or whatever you agree to take or also undertake under the contract, it's within what you can handle. And also I would talk about employee training, right? Clients need to ensure that the employees are, as you said, are aware on the extent of, on the current stage of like how AI can either dilute the trademarks or leak trade secrets. So employees need to ensure they are not imputing key and confidential information into these AI models. So that's the second aspect I would come from. Then with respect to, let's say, ownership of the output, for example, for patents and let's say copyrights, mostly patent per se, and if these outputted contents are created using machine learning or just purely used by artificial intelligence, we need to document this information, because we don't want a situation whereby you apply for a patent and it's granted, and then maybe 5 years down the line it's challenged on the grounds that, oh, was never an invention, and then you don't have any documentation to prove this. So the third part would be the documentation, and then the next part would then be also preventing like your company from claims, like infringing claims from let's say copyright owners. So for that, I'll say companies relying on the fair use doctrine should ensure that when they use this copyrighted work, it's being used within the scope of the defense. So when it means that the outputted product should not be materially the same as the copyrighted product, and also the product that is being commercialized in the end should be significantly different. So if it's something that is being used in-house and that's being used within your team, then maybe we can say the risk is quite minimum. But then once we start commercializing this product, we need to ensure that whatever defense we use or we try to put forth in court should be within the scope of the defense.
As you know, that the users of the AI models comes from different countries and different jurisdictions. So it is actually not practicable to consider all the compliance matters when collecting the data, cleaning the data, So I tell my R&D team to use any methodology or tools to collect as much data as possible, as relevant data as possible, and as high quality data as possible. Because most of the data cannot be used for model training. So if really have some issues in future, leave all the issues to the lawyers. Yeah, I agree with Mr. Yang. So we have to focus. We need to get the very good model performance. I think that is most important because that will benefit everyone in future. Thank you.
Okay, folks, so we have a little bit of time for questions, I think. Do we have anything from the panel? Okay.
So many questions.
I think we're running out of microphones.
Only half of them work.
Sorry, lady first. Thank you for
Sorry about
presentation. Thank you for a presentation, very insightful. Thank you. So my question is about the data training because I checked the Chinwe case in China actually is more or less about data training. So my question is to Marc and also to Kirk if possible. So in terms of data training, so are there any high profile or typical case in the EU regarding under the AI Act, as you mentioned, for the enforcement or litigation involving data training? Thank you.
Well, since you're since you're asking for the AI Act, of course, this is so new. So far, I know there is no case under the AI Act. It will be, I can imagine, very relevant in the future, and I would be happy if the first cases would come to court, so that we get the first rulings on that.
Also the enforcement, the administrative penalties, etc. No outstanding case right now.
Not so far, I know.
Okay, thank you. Thank you.
If it comes to one comment, if it comes to penalties, that is quite interesting because also AI Act does or changes the methodology of fining in the European Union, since the fines can be also related to the company's gross income up to 7%. So this can be tremendously high fines that you're probably facing, and this is why I can highly recommend every company to be very aware when they are dealing with matters that could probably end up in a fine.
To answer the U.S. question very briefly, there are a few cases right now pending, specifically involving OpenAI, because as far as we can tell, they just stole everything they could get their hands on. They did not care. They didn't Silicon Valley thing. They grabbed all the data, and they are facing just a litany of lawsuits as a result. And they are the bellwether for us as to whether or not this is going to survive, because the presumption that most companies have in the United States is that pretty much every commercially available OpenAI model or every commercially available generative AI model is basically built on copyright infringement. Most of them that I was speaking with, I was at a conference last week in LA, most of them openly assume that's the case, and they assume that the courts are going to completely come down on it. Whether or not that happens is difficult. There are some good arguments to be made again about the nature of that being transformed into a mathematical model. We can get into that. OpenAI might be in a bad situation because they do use more than machine learning. They have a search component, which is a problem. The interesting thing to know is the trend I'm seeing is because everyone assumes that it's a landmine, the real discussion has become a portion of liability. The question is not, hey, is this copyright infringing or not? It's, I'm going to assume it's copyright infringing, and I'm going to hire someone else to run it for me so that way they get in trouble, and I'm going to put in that contract, if something happens, you're responsible for it. So most of the companies I know are doing exactly that. They are explicitly in the contract, they say, I don't know how you train this, I don't give a crap. However, if we get sued, you're indemnifying me. That's how it's working.
But it doesn't work.
It does not work.
So I have a question for each of you. Because there's so many points that were made, and some of them were made as throwaway points, just to sort of get some clarity. Kirk, I'll ask you first, and then maybe you'll answer last. But I want you to think through it because other people address it, but I think it's important. say I would recommend an FTO, which is great for lawyers. I mean, I make gazillions of FTOs, thank you, Tingting, for saying good work. But this perhaps the rule, but especially for the US, because this is the jurisdiction where you can really fall flat on your bottom by showing your face mostly. Have a think through, and perhaps the pros and cons of actually doing an FTO in the sphere of AI, where we know in context it's not all in patents, it's not all in copyright, something is in trade secrets, etc. So, or maybe answer the question first. So, FTO, yes, no, what are the risks from a US perspective?
So we have done a survey of the patents out there related to AI, and there are so damn many because the USPTO was just pumping them out like crazy. And look, I was part of that. Like I'll admit to you, there was a period of time where the USPTO examiners would rubber stamp and approve anything that said machine learning on it because they didn't understand it fully. They were intelligent as to their argument, but they didn't actually know what the hell they were looking at when it came to AI. So if we put in a generic description of an artificial neural network, that was sufficient for them to go, boom, allowed, sufficient under 101. Now, we're sent to Panelists to change that, but the reality is, in the United States, there are probably, I think the last time we looked, and this is old, so don't hold me to this, 50,000 granted patents as to direct use of machine learning models.
And China has twice as many.
Right, so there's no way in hell we could issue an FTO saying you're good to go. The reality of it is, if we issued it, it would just be one big word, no. And so, what are you going to do? I mean, we probably wouldn't issue that in the first place just because there's too much out there, but again, in the copyright issues, the trade secret issues, the reality is that most companies I'm talking to are intentionally rolling the dice on this, and they're okay with that. They are taking the Silicon Valley mentality. They're figuring, okay, we'll be but one data point in a larger set of data points of people using these models. Eventually, the courts will bail us out, or the legislators will bail us out. But the reality of it is, just to be very blunt with you, there's a lot of junk out there that I was partially involved in. So there's not going to be an easy way to get out of this, right? If you're in the ML space, at least in the United States, I would conservatively estimate there's a 90% chance you're infringing someone's patent. Whether or not that patent's valid is a whole different question. And then we can get into the full context of getting rid of it. You can go do your invalidity proceedings, your IPRs. Those are fun. I love doing them. But just to tell you very bluntly, the FTO answer is going to be no, don't do that, please.
Yeah, I agree. This is a really good question. And nowadays, a lot of AI companies are going abroad, and in a sense, they need to consider the legal risks in all countries, but that's impossible. Sometimes in the contract, they say, oh, I guarantee that my product, my AI products, is not infringing, full stop. No, they can't do that. We have 192 countries or regions. You cannot guarantee that your product is not infringing in all countries or in all regions. Now, what I advise them is need to assess the risks, key risks in the key jurisdictions, such as states. And unfortunately, the United States is the most difficult states. And you like to sue.
Your fault.
Yeah.
Your fault.
That's how I make money.
Yeah, when we performed FTO, we can find a wide range of patents, and some of patents are rubbish. And since the patent is so broad and so algorithm-centered, how can they be patented? And sometimes I will receive the warning letter from your attorney saying, you are infringing, give me money. Oh, I will say, I will come back with attorney's letter response. They say, according to my research, and your patent is not stable, and if you sue me, I will sue against you. Now, that's my strategy. And of course, in addition to patent, there are some other issues that you mentioned, and sometimes it's about contract breach or the unfair competition, just like an AI want to claim infringement against DeepSeek, right? But how can this be sustainable, right? You use the data trained by another AI for the training of the new AI. If this is prohibited contractually, but are you able to control some data which are original in public domain? Now, that question did not be tested. But overall, we need to learn the law, learn the possible risks, and make balance. And in your case, I will encourage my client to go abroad, provided that we know the risk, how risk is, and we can make some remedial measures. That's it.
Okay, so maybe a controversial perspective, but I think an important one because as those in-house people I'm sitting next to will agree, there's a lot of legislation which originates with lawyers, but they're also politicians, bureaucrats, or even bankers. Is it necessary, a few people have said here, I've sort of a view from South Africa, and also some people yesterday who said, I have to declare my view that less regulation is better. There doesn't mean no regulation. The Russian approach is also not necessarily mine. Just from yesterday, so I just because you remind me doesn't mean I can't see you. Do we feel that it is really necessary to create a new system of laws, governance, etc.? Not to hear about the ethical background and research done in the EU, for example. There's unique history to the EU, which we'll have to acknowledge goes back about 8 years. But is it necessary to have a new system of IP protection for AI? I'm not trying to be provocative here. Anybody's here, anybody chime in, Marc as well. I mean, I'm sure you all have it, particularly have both perspectives, open to all.
Yeah, actually, there is a hot discussion of whether we need to create an AI law or AI legal system in China, and I strongly against that view. Now, why create a new law? Why cannot we rely on copyright law, data protection law for the AI issue? If there is any loops, we can always make an amendment. But why do we need to create a new system which will create problem of the gap between the existing laws or create new issues? Why not? So yeah, I will suggest that we use existing laws to interpret the AI issue.
Please come to Europe and explain this to the European Commission.
I would say, so I've seen some opinions that AI should be treated as a sui generis case, and then the IP laws or existing laws should be geared just towards AI. I would say, while it might not be necessary to regulate specifically for AI, I think it's necessary to review our existing laws to ensure that the current laws is able to satisfy the trends. Because we're talking about today, 2025, but then we see that the state of affairs this year is largely different from how it was in 2019 or 20, or even last year. So the technological space is evolving as quickly as possible, but we see the law is still staying stagnant. For example, like the current existing laws don't allow the AI to own property, right? Yeah. But then we don't know what might happen in a few months or maybe next year. We might see some improvement with respect to property law. Maybe the property law might be more. I don't think so. No. I'm not seeing so much of that. But then, if the IP law is remaining stagnant, and then other aspects of regulations are moving with the time, then we see that our existing IP laws cannot satisfy the wave of invention that is coming up. So generally, I would say we don't need to have a special IP AI law, but then our existing IP laws needs to be updated as invention progresses.
Tingting.
I think most of the issues arises this morning is because we are still treating the AI model as a tool, not the co-worker. Even the costs in different jurisdictions and thinking this way. I also think that each large-scale language model does not have the access to the IP system of different countries, right? So I'm not sure why we still need the specific laws or regulations and regarding this issue. Thank you.
You know, if you treat AI as a co-worker, how long before they become your superior? And I'm serious. Matthew, what's going, can you ask the AI? Because I'm not sure about your answer. Can you go and ask the AI? I mean, I'm much happier if chat tells me, my friend chat. Because Marc, I mean, you're human and your memory, who knows you had a bad night? Because chat had a great night. So can you check the chat? Because, and before, by the way, chat got a promotion.
Yeah, some patients will bring DeepSeek to the hospital. Say, hey, DeepSeek say that. Fortunately, then no one come to me with...
There's this wonderful cartoon I got from a doctor in Australia. It's a snail that's sort of dead. And then the other snail comes in and there's this box of salt. and this is Dr. Google gargle with soap snails. So it's a little bit like that, isn't it?
Yeah.
Sorry, just to chime in. So, like, I know we're all saying it's really scary to say to treat AI as our colleague, but if you look at the trends, that's practically where we are heading to right now. So most people, like, not, I would say most people, like many people rely on AI. So it's like this AI era might be likened to when search engines like Google, Bing, Baidu came about. You see, when you have a question, before these search engines were in existence, when you have an issue, you can go do your research, you go to the library. But once this, the invention of this, when you have a question, like, oh, ask Google or ask Bing. So it's still going to be the same. So we ask AI. What does ChatGPT say about?
So meet Ivy, she's my NI, natural intelligence.
Well, there is just one maybe funny compromise. I was in a discussion with a colleague, not lawyer's colleague, but a programmer, and he's a kind of visionary, and he was speaking about probably you could marry a robot, and they're the first developers working on humanized robots. So Elliot, probably when we meet next or the year after, we will meet on a robot marriage show.
I was going to say, I thought he was talking about, I mentioned nationality there.
Well, I know at least one divorce today. It's a fun story. Anyway, we have officially run out of time. Let's thank our fantastic panelists for their time. Handing out plaques. Wow, Jesus. All right.
Dr. Matt.
Marc?
Marc first? Yeah, thanks so much.
Chinwe.
Over here, sorry. Thank you very much. Thank you.
Thank you once again for such a nice opening session. Now we'll move to the next short networking break, a coffee break for 5 minutes, and we'll resume with our next special talk by Chris. Thank you.